Hi, I'm Daniel. I'm a lawyer in the British Virgin Islands, also known as the BVI, and at times I help my mother out in her bookshop, Serendipity Books. This is my first video explaining various legal concepts, so forgive me if it sounds a bit robotic or mundane. Today, we will be discussing mortgages and the mortgagee's power of sale. The content of this video is purely educational and does not constitute legal advice. So let's jump right into it. What is a Lord Templeman, in the case of Downsview Nominees Ltd. and First City Corp Ltd., said, "A mortgage is a security for the realization of a debt. A mortgage comes into being by an agreement between a borrower and a lender. In that agreement, the parties agree to attach property to the loan so that if the borrower fails to repay the money, the lender can sell that attached property in order to recover the amount owing on the debt." To mortgage land, shares in companies, vessels, and aircraft parts. We will just be discussing mortgages relating to land. In England and Wales, the mortgage agreement must be registered at Her Majesty's Land Registry, and in the BVI, the agreements must be registered at the local land registry as well. A lender is known as a mortgagee, and a borrower is known as a mortgagor. The specific definition of a mortgagee, however, is a person who has a registered interest in a given property by virtue of such property being used to securitize a debt or a loan. A mortgagor, on the other hand, is the person who owns the property that has a mortgage registered against it. In some jurisdictions, such as the British Virgin Islands and Cayman Islands, a mortgage is known as a charge, a mortgagee is known as a chargee, and a mortgagor is known as a chargor. In England and Wales, mortgages are largely governed by the Law of Property Act 1925 and to an extent the Land Registration Act 2002. In the Cayman Islands and BVI, mortgages are governed by the Registered Land Law and Registered Land Act, respectively. If the mortgagor fully pays a debt, the mortgage is discharged and the mortgagee no longer has any legal or equitable interest in the mortgaged property. Upon being notified through the prescribed manner, the land registry must reflect the discharge of the mortgage or charge in the land register. So, what happens when a mortgagor fails to abide by the terms of the mortgage agreement? In England and Wales, the mortgaged property can be sold either through a public auction or through private negotiations. In the BVI and Cayman Islands, on the other hand, only sale through a public auction is allowed. Before a mortgagee can exercise their power of sale, one or more of the following conditions must be met. 1. Notice requiring the debt to be paid has been served on the mortgagor, and the mortgagor fails within a period of 3 months of receiving that notice to pay the balance. Interest on the amount is in arrears by 2 or more months. Or 3. The mortgagor has failed to abide by either the statutory obligations or a term in the mortgage agreement, which does not relate to the payment of money. In the and Cayman Islands, the conditions to be met are as follows. If a period of 1 month goes by where the mortgagor is in breach of their statutory responsibilities or a term in the mortgage agreement, which may include terms relating to the payment of money, the mortgagee may serve a notice on the mortgagor requiring that the breach is remedied in a period of 3 months. Or in other words, the mortgagor must comply with the agreement and the statutory obligations within 3 months after receiving that notice. And if after that period the mortgagor is still in breach, the mortgagee may exercise their power of sale. If the mortgaged property generates an income, they also have an option to appoint a receiver to collect the money generated until what is owed has been paid off. Before we end, let's take a brief look at a scenario. Harry loaned $108,000 from Crooks Bank in order to finance his business. He secured the loan with one of his office buildings, and in doing so, he created a mortgage. Crooks Bank registered the mortgage at the Land Registry Office in order to make it effective. Under the mortgage agreement, Harry agreed to pay $3,000 per month for 3 years, from the 5th of January 2017 to the 5th of January 2020. He was up to date with his payments until July 2018, but then Harry, who is independently wealthy, got bored with his business and decided to stop paying the mortgage. Unfortunately for Crooks Bank, they received no payment for August 2018, and thus in September 2018, they served Harry with a notice requiring payment by December. Having received no payment or even a reply, Crooks Bank had no choice but to employ Bad Beans Real Estate to conduct a valuation on the office building. Bad Beans provided Crooks Bank with a valuation of $22,000. However, they forgot to consider the fact that the office building was in a prime spot in the city and that it was fully rented and generating an income of $300,000 per year. Crooks Bank then advertised the sale of the building via public auction to be held on the 22nd of January 2019 and set the reserve price at $22,000. The amount remaining on the mortgage was $50,400. The office building sold for $22,400. After applying that amount to the mortgage, Harry still had a balance of $28,000 owing to Crooks Bank. Crooks Bank then sued Harry for the remainder. Harry alleged in court that the value of the office buildings was actually $3 million and that Crooks Bank's valuation was arrived at negligently. The court found in Harry's favor despite his extremely naughty behavior and ordered that Crooks Bank pay him $2,972,000 plus legal costs. Thanks for watching this video. I know I didn't cover the entirety of mortgages, but I hope this video helped you understand the basics. Please leave a like if it did. If you want me to cover a specific topic, please leave a comment below and I'll try my best to cover it.